Thank you to the Caribbean ADR Initiative, Shan, Baria, for the opportunity to speak with everyone today. I'm going to start by just introducing the legal framework governing arbitrator independence and impartiality in the Caribbean. And then we'll take a brief look at how that concept has played out in practice. And finally, how the perception of the framework and the culture play a role in maintaining and strengthening the overall system of justice. So in terms of the framework, into the fabric of the legal systems in the Caribbean, at the foundation basically of every civilized society, there are certain principles woven that include fairness, equality before the law, and justice. And the bodies that are charged with the responsibility for the administration of and delivery of justice must, in order to achieve these objectives, adhere to fundamental, immutable tenets that tend to promote respect for and confidence in and obedience to the rule of law and the legal systems that support it. And foremost among the principles of natural justice is the right of a person to be given adequate notice of the hearing of the charge against him and an opportunity to be heard in his defense, followed by the principle that a tribunal or adjudicator must be disinterested and unbiased. Now, the constitutions in the Commonwealth Caribbean, by and large, reflect these principles. They enshrine the concept of natural justice, precepts of fair hearing, and freedom of bias. For example, the Barbados Constitution, for example, provides that every person who's charged with a criminal offense or whose civil rights and obligations are being determined shall be entitled to a fair hearing within a reasonable time by an independent and impartial court, or in civil cases, authority established by law. Now, of course, by and large, these constitutions regulate state action and public authorities. So therefore, you might not be surprised to learn that it has been held, at least in Barbados, that constitutional remedies don't apply to private arbitrations. And the case that stands for that proposition is the similarly related Alto Guadalupe Investissements Limited against Henri Alvarez et al. That's a 2013 case. And this was an action brought by AGI under the Barbados Constitution for breach of the right to a fair hearing within a reasonable time by an independent and impartial court or authority established by law. Now, the High Court of Barbados rejected the applicant's request for constitutional remedies because the court found that the powers, duties, and functions of the arbitral tribunal are derived from the arbitration agreement in question. They don't derive from statutory authority, and they're not of a public character or nature. But the question is, does that mean that private tribunals are somehow exempt from all accountability in the administration of arbitral proceedings? And the answer is obviously not. Like judges and magistrates and other public decision-making bodies, arbitrators discharge their functions within a niche segment of the entire institutional framework of justice. Now, I'll take a quick look at the domestic legislation. And as Shan mentioned earlier, several Caribbean islands have antiquated or have based their legislation on antiquated 1950 Arbitration Act of England. But even in that act, built into that act is the power of the court to remove an arbitrator from his appointment on the basis that he's misconducted himself or the proceedings. And the act also provides that the award may be set aside on the basis of arbitrator misconduct. Now, while misconduct is not defined in that legislation, cases in the Caribbean have relied on English case law in which to frame the concept of misconduct, and that tends to be consistent with English concepts of tests for bias, to determine independence and impartiality on the part of the arbitrator. Now look at the first case that I'm looking at, and I'll, like Murray said earlier, unfortunately I won't be able to give you the citation during the presentation. What I will do is, if you email me at or Barry, or you can reach out to me on LinkedIn. I will be more than happy to provide you with any case citations. And my email address is tammi.pilgrim@bb.lexcaribbean.com. It's a bit of a mouthful, but you can find me on LinkedIn if that is a bit difficult to remember. Now, the first case that I'm going to look at is a Jamaican case. It's called R.A. Murray International Limited against Brian Golson. It's from 2012. And this case discussed the concept of misconduct and indicated that the expression misconduct is of very wide import. It does not necessarily connote that the arbitrator has been guilty of moral turpitude. It ranges from a fundamental abuse of his position, i.e., on the one hand, that is misconduct, which by any standard, such as being bribed and corrupted, to, on the other hand, a mere technical misconduct, such as by making a mere mistake as to the scope of his authority, and that is the authority conferred by the reference. And that doesn't mean that every irregularity in procedure amounts to misconduct. Also in the 2018 case in St. Lucia called Paul Limerick against Christian Brown, the court in that case adopted the dicta of the English court in Williams against Wallace and Cox as to the meaning of misconduct, and says the expression does not necessarily involve personal turpitude on the part of the arbitrator, and any such suggestion has been expressly disclaimed. The term does not really amount to much more than such mishandling of the arbitration as is likely to amount to some substantial miscarriage of justice. Now, as Shan mentioned earlier, this test, the discussion on arbitration misconduct might seem as though it leads away from international standards or the consistency of international cases on the question of arbitrator impartiality and the test therefore. But as we'll go on to discuss, they actually are a little bit closer than we'd actually think. But I agree with Shan that the Caribbean islands should seek to update their legislation, but we'll take a look at that shortly. As Shan mentioned, some Caribbean islands, and I can name, I think, at least Barbados and Jamaica off the top of my head, have also enacted legislation based on the Untitled model law, which outlines an arbitrator can be challenged only if circumstances exist that give rise to justifiable doubts as to his impartiality or independence, or if he does not possess qualifications agreed to by the parties. But there is an ongoing obligation in the model law, given in the model law, on the part of the tribunal to disclose any such circumstances throughout the entire arbitration proceedings. The model law also sets out a challenge procedure, which includes basic timelines for the submission of reasons for the challenge to the arbitrator himself. And this is because Article 16 of the Untitled model law adopts the principle of competence and of separability of the arbitration clause, meaning that the tribunal may independently rule on the question of its own jurisdiction, including the validity of the arbitration agreement, without recourse to the court. Because the legislation in the Caribbean is by and large based on the vintage English legislation, there has been quite a bit of work done in order to pave the way for updated legislation for all the islands. And I refer here to the stellar work that's been done by the Impact Justice Project, which was created with the aim of improving access to justice throughout the Caribbean. Now, the project produced, I think in 2017, the Model Arbitration Bill in order to modernize and harmonize arbitration laws in the Caribbean. Now, the Model Arbitration Bill adopts the Untitled model law's grounds for challenge to a tribunal, namely that circumstances exist which give rise to justifiable doubts about the arbitrator's independence and impartiality. The model bill also upholds the tribunal's ongoing obligation to disclose any such circumstances I mentioned, and also adopts the challenge procedure. Under all of the legislation that I mentioned earlier, whether it's the Impact Justice Model Bill, whether it's the Untitled Model Law, or the domestic legislation, the old domestic legislation modeled off the 1950 English legislation, the court remains the final arbiter on the question of the challenge to the arbitrator's independence and impartiality, whether during proceedings in a challenge aimed at removing an arbitrator or after the award, as a basis on which it might be set aside. Now, in practice, what has engaged the court's attention is not the obvious case of a bribed arbitrator, in which case the tribunal is automatically disqualified. It's usually the question, the tricky gray area of apparent bias. Now, regarding the freedom from partiality in adjudicator, this concept requires that not only should the tribunal be independent and free from actual bias, which, for example, a financial interest in the outcome of the proceedings, but it must also not appear in the objective sense to lack impartiality. And that statement's actually taken from one of the leading cases on this subject, which is Porter against Mcgill. Now, the test for apparent bias that's stated in Porter and Mcgill and is reflected in quite a few of the questions in the cases that speak to arbitrator impartiality was made in Porter and Mcgill by Lord Hope of Craighead, where he formulated this principle. The question is whether the fair-minded and informed observer, having considered the facts, would conclude that there is a real possibility that the tribunal was biased. Now, as I'll outline below, this test has been used to apply in cases where the independence and impartiality of both judges and arbitrators come into question. But the foundational step is, who is this fair-minded and informed observer? Now, in the case of the Attorney General of Trinidad and Tobago against Dr. Wayne Kubel-Singh, the characteristics and nature of the independent and fair-minded observer were described. And if you'll bear with me, I just want to outline them quickly because I'll ask you afterward if this sounds like many people that you know. Now, the High Court matter concerned an application by the Attorney General. The Attorney General requested the High Court judge to recuse himself on the grounds of apparent bias. The trial judge refused to do so, rejected the application, and of course, the Attorney General appealed. And on appeal, the Court of Appeal agreed with the judge at first instance. And in relation to the characteristics of the independent and fair-minded observer, he said, being fair-minded, he always reserves judgment on every point unless he has seen and fully understood both sides of the argument. He will therefore not come to hasty conclusions, and he is not to be confused with the person who made the complaint. The fair-minded observer is informed. He can distinguish between what matters are relevant and what are irrelevant, and he will take the time to inform himself on all matters that are relevant. He is also able to determine what weight should be given to facts that are relevant. And he's able to put whatever he's read into the overall context and will appreciate that context forms an important part of the material that he has to consider. Furthermore, the fair-minded observer is not complacent. He knows that fairness requires a judge must be seen to be unbiased. And he, however, knows that judges have their weaknesses and therefore will not shrink from the conclusion, if it can be justified objectively, that things judges may have said or done or associations they may have formed may make it difficult to judge the case before them impartially. He will note the oath that the judge takes is a factor to be considered, but not treated as a guarantee of impartiality. He will assume that he is a member of the community in which the case arose. He will possess an awareness of local issues and social and political reality that forms the backdrop to the case gained from the experience of having lived in that society. He will assume that the judge, by virtue of his actions, his or her office, is intelligent and will be able to form his or her own views and be capable of detaching his or her own mind from things that he or she does not agree with, and is aware of the legal traditions and culture of this jurisdiction, and that culture plays an important role in ensuring the high standards of integrity on the part of the judiciary. The fair-minded observer is not an insider. He's not a party to the action. Most importantly, he is not unduly sensitive or suspicious. Now, while that may seem long, it's interesting to me, at least in my experience, the number of balanced and fair qualities that this fair-minded observer is required to have. And the truth is, at base, the fair-minded observer is a judge. The fair-minded observer must detach himself from all aspects of his own views on things and surround himself with, review every single consideration and fact to determine what is relevant and what is irrelevant. And most importantly, he's not unduly suspicious. So in these Trumpian times, that signals that he's more clued into objective reality. Now, this test has been applied in the arbitrator context, and I'll just take two cases as an example. The first is in fighting technologies against the AG, and in this case, this is a Barbados case from 2013. The arbitrator in this case disclosed that he was at the time sitting on proceedings in an international arbitration, and on the panel with him in those proceedings happened to be a member of the legal team for one of the parties. And when he disclosed that, he sent an email to the parties notifying them that he was sitting with that particular counsel in pending arbitration proceedings. And when that occurred, there was the obvious challenge. The court the challenge was made to remove the arbitrator under the old domestic legislation, as I mentioned before. And the court in that instance adopted the Porter and Mcgill test and stated that indeed both men would have been subject to human failings, but any suspicion would be outweighed in the mind of the fair-minded observer by the fact that the individuals involved were lawyers, experienced lawyers of the highest caliber, and that the arbitrator is an experienced arbitrator with some judicial experience. He would also consider that given the arbitrator's professional standing and experience, it would not be expected that either gentleman would seek to influence each other in the conduct of, influence the arbitrator in the conduct of the arbitration. The court in this case determined that the fair-minded observer would be taken to know the culture and traditions of the legal practice, and determined that there was no grounds on which an allegation of apparent bias could be supported. In St. Lucia, in 2018, the case of Daria against the Eastern Caribbean, I think Insurance Company Limited, the arbitrator received from the defendant the claimant's share of fees without informing the claimant. Now, in accepting his appointment, he indicated to all parties that he did do work for the insurance company from time to time, but no objections were made to his appointment. And the arbitrator indicated to the parties at the end of the proceedings that the award had been prepared, and he asked the parties he sent his invoice and he asked the parties to pay the invoice so that he could render the award. And the expectation was that the parties would share the payment equally. The defendant paid its share, but the claimant indicated that it was having difficulties in meeting its contribution. So 2 months after the defendant paid its share, it then tendered to the arbitrator the claimant's share of the fee on the basis and on the expectation that it would be refunded by the claimant and that the arbitrator would go ahead and release the award momentarily. The decision was rendered shortly thereafter, and the claimant then sought to set it aside on the basis that the arbitrator had misconducted the proceedings because he was biased. Now, the claimant's counsel argued, and the court accepted, that payment by one party to an arbitration of the fee for the award in circumstances where the other could not was normal practice. And even though the claimant alleged that she suspected that there had been communications between the arbitrator and the defendant, the court found that that was without evidential foundation and based on speculation only. Excuse me. The claimant, the court also suggested that the facts that weighed in favor of the arbitrator being unbiased was that the award itself was not tainted. The award itself was balanced, and there were points decided both for and against the defendant in the fact of disclosure. Now, in this case to me shows that the court won't support conspiracy theories about the system. Now, the claimant had argued that there was some clandestine communications between the arbitrator and the defendant, and that was just not supported by the evidence. And at this point, the court reminded the litigants that the fair-minded observer is not unduly suspicious. Now, the final case I'll quote to you on this point is the same Auto Guadalupe Investissement Limited against Columbus Holdings. And we call it the AGI case. And in the AGI case, the Court of Appeal was being asked to stay proceedings of an arbitration. And the court refused. The court said that the principle that is enshrined in Article 16 of the Institutional Model Law and in the Barbados International Commercial Arbitration Act supports the principle of competence, and for the court to stay proceedings in those circumstances would amount to ignoring the model law's separability principle. These cases, at the end of the day, all these cases show the court remains the final arbiter on the question of impartiality, and the court is willing to stand in the shoes of the fair-minded observer and take all circumstances into account. And it won't support conspiracy theories, and it won't support mere associations. So in the Daria case, where there was a clear association, a professional association between the arbitrator, and the defendant, the court found that there had to be something more in the evidence than just that mere professional association, even though that association was based on work. Now, I'm just going to wrap up very quickly to speak about these principles are, in theory, governing the public's confidence in the arbitration system and in the litigation system. But on the ground, there continues to be a sense of dissonance between how these principles are supposed to work and how they actually do work. For instance, I have had, in my experience, several times, especially when there's been a controversial decision made, comments made such as, well, these people are friends. So, for example, in the more recent case before the Caribbean Court of Justice, in relation to the elections in Guyana, there were several negative comments made about the Caribbean Court of Justice's role in coming to certain decisions in that case. And there were these allegations that somehow the judges may have had a financial interest in the outcome of the proceedings. Now, all of those allegations are not based on, they have no evidential foundation. And in those circumstances, it's my belief, certainly, that we need to find a way to bring the concepts of fairness and independence and impartiality, both in the public sphere and in private arbitrations, because the two are symbiotic, to the laypersons on the ground and the persons who actually use the system, so that there's educational awareness and understanding that the fundamental underpinnings of the system have not changed, and that the fair-minded and independent observer is not one who is unduly suspicious and who will not support conspiracy theories. Now, the last, and I probably will use this in the breakout rooms as part of the discussion, but the question that I have for all of you is, what do you think we can do as users of the system to support a change in that mindset, and to support an understanding that there's no need to be suspicious of the system, and to support an understanding that the system continues to have these logical, civilized foundation underpinnings to it of fairness and justice. And that concludes my presentation today.